What that nigga say?
Oh, Cheyenne, oh. Cheyenne and Leo. Mr. Thomas,
Yes.
hi, good morning. What case are you here for this morning?
For Metro Commons for eviction, just to
Hold
make
on.
arrangements.
Not in this court. Hold on one second. Mr. Thomas, do you have a case number?
Yes, 1 second. I'm going to get it for you.
Okay, thanks.
Project.
This is 220458 GC Sonia Bonnie McIntosh and Edward McIntosh versus Speed Marcel Miller and Arlana Miller Brown. May I have your appearances, please?
Attorney George Long appearing on behalf of the plaintiff, P79687.
Thank you, Mr. Long. Defense attorney is here. I can see him logged on. Mr. Opalewski? Your appearance, please, sir.
Oh, hi, Your Honor. Sorry, I just also got pulled into the circuit court. Can I just find out if they need me right now? Right, which
Yes,
it doesn't
sir.
appear they do. Never mind. Attorney Nicholas Ryan Opaleski appearing on behalf of the members.
Are you sure you don't need to check in with circuit?
Yeah, because it looks like they just called a different case.
Okay. Today is a pretrial and the motion for summary disposition. Just so that we're clear on the record, the court did timely receive the motion for summary as we discussed at a previous hearing. The pretrial and motion date were September 20th at 9 a.m. On that day, Mr. Long appeared. Defense counsel did not appear, but inasmuch as Mr. Long had not filed a response to the motion, the court adjourned the hearing to today. That being the case, the court having now received and reviewed the motion and its response. Mr. Opalewski, this is your motion. Please proceed, sir.
Your Honor, I don't know how much you really want me to get into this. You know, and I know you have the brief, so I don't want to repeat myself on some of these issues, but I think the key points to take away from the brief are that my clients are not in contract with the plaintiffs. I believe that the contract's crystal clear who is. Matter of fact, this was even discussed at their motion to amend the complaint. And the court even kind of alluded to, you know what, I'm going to allow them to add anybody, you know, kind of alluding to maybe they should add the business, and they didn't do it. The contract is with the business, and Michigan law says that, you know, if you want to, you got to show something to pierce the corporate veil, or you have to plead it, and they haven't done that. They didn't plead piercing the corporate veil. As much as I admire this court, I don't believe the court has the equitable jurisdiction nonetheless to do that. But nonetheless, it hasn't been pled, so we don't get to that argument anyway. Further, Your Honor, we get to, again, animal, you know, we get to the animal cruelty part of this, the negligent animal cruelty. When we look at, so if we looked at this in the realm of tort, there's, of conversion. There's statutory conversion and common law conversion. And courts have found many times that a party shouldn't be left guessing which one they're being sued for. So the same point here. Are they suing? Are they trying to borrow the criminal statute for animal negligence, or are they going with common law negligence? They don't plead that. So we don't know what they're trying to do, and we shouldn't be left guessing. Nonetheless, once again, still not the proper party. So, and then I think that, you know, the only thing I really want to say about the intentional infliction of emotional distress, it is well-founded. I mean, just case after case after case, that there is no, and this is quoting the higher courts, there is no precedent in Michigan that permits the recovery of damages for emotional injuries for property damage. They just don't allow it. And I mean, that's well said. So realistically, their complaint, I believe, fails on all counts, and it needs to be dismissed.
Your response, Mr. Long?
Yes, Your Honor, if I may please the court. The defendant's attorney makes light of the contract and stating the correct defendants are not in court. And he sought to admit parole evidence that we believe that should not be admissible as far as some LLC that was not stated in the contract. The contract speaks for itself, and under the Four Corners rule, they not bring in any inconsistent evidence or contemporaneous evidence that's inconsistent with the contract. Here on the contract, it says it makes no mention of an LLC at all. So it would be improper for Mr. Opalowski to bring in any type of evidence to state that Mrs. Arlana Brown and Speed Miller are protected under an LLC. You should look no further. This is a completely integrated contract. It's the final written expression of the parties, and it makes no mention of an LLC. So the Miller's Farms, it says here, stable name, Miller's Farm, and we do have the Millers, and they have Speed and Arlana. So we disagree that the correct parties are not in court, Your Honor. As far as piercing the corporate veil, it goes along with the same line of law here that we're not attempting to pierce a corporate veil that doesn't exist. No protection is allowed under an LLC that is not expressed in the agreement. The protections of the LLC, the purpose is to provide notice to a contracting party that they are that the parties they're contracting with are protected. They're limited liability. There's no mention or notice anywhere in this contract at all about Farms LLC. To my knowledge, the plaintiffs did not even know that a Miller's Farm LLC existed until Mr. Opalowski wants to introduce parole evidence. The animal cruelty charge allegation, Your Honor, is based on the notice.
I'm sorry, Mr. Long, is based on what?
Based on the fact that the defendant had a duty, breached that duty, and the cause and fact, and my client has damages. As far as the correct standard of review, again, Michigan is acts under a notice pleading stage. The defendant is giving notice that he must defend these allegations. They're clear and concise, and there's no doubt that my client has a case for animal cruelty, Your Honor. As far as the intentional infliction of emotional distress, we believe that it speaks for itself and that the defendants did intentionally. We have evidence of the intent based on the reports that we provided in our exhibits that the animal was not provided reasonable food, shelter, or care. The defendants had an obligation, as stated in the contract, to provide even necessary medical treatment for that animal. And they intentionally withheld that medical treatment, food, water, and shelter until that animal died. They moved that animal out of the jurisdiction or the place of contract without knowledge to the plaintiffs. In fact, the defendant, one of the defendants is wanted in Calhoun County right now for an
One
arrest.
of the, I'm sorry, Mr. Long,
Objection.
one of, Mr. Stop. Mr. Long, one of the defendants, what? I can't
Is
hear you on
wanted
that
in
part.
Calhoun County for animal cruelty. And I believe, possibly.
Arising out of this case, Mr. Long?
It is, this is regarding this horse, this animal. He took this horse to Calhoun County, which is where that horse was. And left without water, without food, without notice or consent of the plaintiffs. We're requesting that you ask Mr. Opalowski to tell his defendant to surrender himself to Calhoun County. I believe he knows that his defendant is wanted in Calhoun County. Furthermore, Your Honor, we believe that this case and the evidence provided that is in my responsive motion is sufficient that a reasonable trier of fact could find that the defendants have breached the contract, that they have committed animal cruelty, and that they intentionally inflicted emotional distress upon the plaintiffs. We believe there's sufficient evidence that this case should be allowed to go forward, Your Honor, and that the motion for summary disposition should be denied. That's all.
Thank you. Any
Very
response,
brief,
sir?
very brief response, Your Honor. Whether or not Mr. Long believes that they could succeed on a claim for emotional distress, the courts are crystal clear. They don't allow it. The case law speaks for itself. Michigan does not allow for intentional infliction of emotional distress concerning personal property. The law is clear. So that must be dismissed. As far as the negligence claim go, I mean, I think the negligence claim and the breach of contract claim go hand in hand. First off, if we believe what Mr. Long says to be true, then no business will ever receive the protections of the Michigan LLCs and corporate acts, okay? Here's why, Your Honor. Best Buy. Best Buy is a big box store that just says Best Buy, but it's owned by somebody. It's owned by an LLC. McDonald's, they're all independent franchises owned by LLCs. We don't know who those LLCs are until we try to sue them. Okay, so if we believe what Mr. Long says to be true, that means every corporation and LLC in the state of Michigan is subject to their agents, officers, members being sued because they don't put LLC, we don't put McDonald's LLC on the sign. Further, Your Honor, the contract states stable names, Miller Farms, stables agent's signature, agent's signature. It doesn't say signed by the Millers. It says stables agent. We're not using parole evidence. We're using a contract. These arguments are, they're not founded in logic at all. Further, even if we look at the negligence, the contract prohibits, since Mr. Long says he wants to talk about just the four corners of the document, paragraphs 4, 5, and 6 say that it is the McIntosh's responsibility to treat their sick horse. They did not do so. And that the stable shall not be liable for sickness, death, theft, injury, or other damages suffered by the owner because of the boarding. Everything that they're claiming is sickness, it's death, it's injury, literally waived in the contract, Your Honor. So if Mr. Long wants to talk about parole evidence, I would suggest that he read paragraph 4. Because clearly this contract says that my clients want to be held liable, but they're not even the responsible party. The farm is. And we've given them 3 bites at the apple and they still haven't taken that bite. This complaint needs to be dismissed, Your Honor. I mean, just as a matter of law and as the contract, it has to be dismissed.
As provided when the case was first called, the court has reviewed the motion with its attached brief and the response in its entirety. First time reviewing this file was back in March of this year, and the court has over time allowed for alternate service, removed from the small claims docket to the general civil docket, allowed parties to be added, allowed the complaint to be amended. And when we appeared on July 6, 2022, we had quite a discussion about process procedure, and defense counsel forecast what his next steps would be. And the court inquired of plaintiff's attorney, are you sure this is how you wish to proceed? Saying all that to say that Mr. Obolewski is accurate and correct in stating that the sole contract between the parties is the horse boarding contract that lists the stable as Miller Farms. This court has gone through great effort to find where defendant number 2, Arlana Miller Brown, is ever listed anywhere. And even with respect to defendant number 1, Speed Marcel Miller, his connection seems to be as the stable's agent. As defense counsel has accurately stated, signing as an agent does not create any greater liability for Mr. Miller than it would for the agent who signed on behalf of Best Buy. That being the case, the court will find that the plaintiff has failed to identify and name the proper defendants in this case, that there is no allowance for intentional infliction of emotional distress as relates to the personal property of the plaintiffs in this matter, that the contract signed by the parties and authenticated by plaintiff as evidenced by his attachment of that document to the response provides that the stable is not liable for sickness, death, theft, injury, or other damage, will grant the defendant's motion by dismissing the plaintiff's complaint in its entirety. Defense counsel will submit an order in that regard. Anything else on behalf of the defendants?
Your Honor, the only thing I would ask is that dismissed with or without prejudice, Your Honor?
We request leave to
Without prejudice,
refile.
we've never gotten to the merits of the underlying contract. I'm sorry, Mr. Long, were you saying
We
something?
request leave to refile, Your Honor, without prejudice.
The dismissal is without prejudice. We haven't gotten to the merits of the underlying contract. I don't want to foreclose the plaintiffs from filing properly. Anything else, Mr. Long?
Your Honor, I would just like to add that I know you made your ruling, but in consideration that I believe that, and I will consider appeal, that this paragraphs 4 and 5 does not preclude intentional acts by the part of Miller Farms or Speed Miller, and also that fail to contact the owner regarding medical care and to provide reasonable medical service under paragraph 6. That'll be all, Your Honor.
Thank you, sir.
Your Honor, I guess the last question I have is, in our brief, we did ask for attorney's fees. Is the court willing to consider those at this time?
Did you have a specific ask in mind, sir? I know that there have been an award for attorney fees previously.
The previous award was for the amended complaint. We would just ask for 1,500 for having to prepare the brief, go through all that, knowing that that my clients weren't the proper parties to begin with. That's what we would ask.
We would object to attorney fees under the American rule. Each side pays its own attorney fees and costs, as well as this case is not a frivolous case. My plaintiffs.
I'm sorry,
have
this case
merit.
is not what, sir?
This is not a frivolous case, Your Honor.
Okay,
The plaintiffs did have cause to charge and bring these allegations against both plaintiffs. Both defendants. As it's been shown here by the court that the case is not being dismissed without prejudice because the merits have not been determined yet. So we would suggest that attorney fees and costs at this time.
your audio cut out for a second, sir.
We would request that you deny the defendant's request for attorney fees and costs at this time. Your Honor.
Anything else on behalf of defendants?
No, Your Honor.
The court will deny the request for attorney fees. There have been attorney fees previously awarded. Mr. Obolewski, respectfully, the court was in a position to dismiss the case when you failed to appear on September 20th. I think that both parties should remain responsible for their respective attorney fees. I'll await your order on your motion.
Yes, Your Honor, I'll have that over to you today.
Thank you, sir. Have a good afternoon. Have a good day, Mr. Long.
Thank you, Your Honor.
Whenever you're ready. Yes, please.
I'm on my way out.
Thank you, ma'am.
Yep.
Did you hear back from Mr. Robinson?
No, I have not.
Okay,
Mr. Thomas?
I'm not leaving, I'm just grabbing.
Yes, I couldn't find my case number. I've been looking for it. I
It's
couldn't
okay.
find it.
You know what? I spoke with the civil department and they said that they don't have anything for you. And they looked you up in the system and they can't find anything.
That's
So-
because it's probably under my wife's name. 'cause it's-
well,
Mary Ann,
Yes.
Mary Ann, you can head on out. Mr. Thomas, give me 1 second.
All right.
What's your wife's name, sir?
First is ITANISE,
Her
That's
last
the
name is
first.
Thomas.
Crawford Thomas.
Is it hyphenated Crawford Thomas?
Yeah. Yep, hyphenated.
224499.
Sure.
It's tomorrow with me at 9 a.m. You're just a day early, sir.
Okay. All right. So is this the
Okay.
same? Is it the same Zoom number?
Same Zoom, back with me tomorrow morning at 9 o'clock.
Okay.
Okay?
Appreciate that. Thank you. Have a good one.
I'll see you in the morning, sir. Thank you. Good morning.
Morning, Your Honor.
This is 223450 LT. This is Tommy Sue Schramm versus Rob Mills. Ma'am, please state your name for the record.
Tommy Sue Schramm.
And your name, sir.
Robert Rose.
Thank you. We were last here on September 28th. and the Court adjourned the case to this morning for the parties to appear with documents in support of their claims and defenses. The court made that request as Mr. Mills has requested a jury trial in this matter. And before the court can schedule the matter, we need to be sure that there remains a triable issue by and between the parties. When we appeared, Ms. Schramm had a copy of an agreement to lease the premises that Mr. Mills indicated there was a more recent document signed between the property owner and himself. Have you, Ms. Schramm, appeared with all of your necessary documents and witnesses this morning?
I have, but I do not have what he stated. I have what I showed you before.
Okay,
I have nothing more recent.
okay. And Mr. Mills, have you appeared this morning with all necessary documents and witnesses?
Yes, Your Honor. Not with any witnesses, Your Honor, no.
Do you have everything you need to proceed this morning, I guess is
I
the
have
better
the
question.
document you requested, yes, Your Honor.
Okay. Have you shared that document with Ms. Schramm? As of
I
yet?
left Mr. Stram a voice message. No, she has not had a copy of this. I invited her to meet with me prior to the state, and I did not get a response.
Okay, before the court reviews it, she'll need to see it, so Officer Brooks will take it from you. And we have one unrelated matter. Mr. Martinez, what are you here for, sir?
I'm here, I believe it's rent.
Is
I-
your landlord Country Meadows?
Yes,
Mr. Martinez, you're supposed to be here tomorrow morning, Wednesday, the 19th at 9 a.m., back with the same Zoom ID information, but just a day, you're just a day early, sir.
I am so sorry. I did.
Don't be sorry. I'll see you in the morning.
All right.
Have a good day.
You too. Bye-bye.
Bye-bye. I saw him pop in, and so I pulled his name right up and I saw LLT. Are they the same thing? Oh. No, they're not the same thing. So the court is in receipt again of the copy of the lease agreement on the goldenrod paper that Ms. Schramm had previously provided. And Mr. Mills, the defendant in this case, has passed up a lease agreement that does not, these are not the same document. These are noticeably different documents. That proffered by Mr. Mills does in fact have a signature page and appears to be signed by Leonard Schramm on February 16, 2012. It's not countersigned by Mr. Mills. Ms. Schramm, you've had the opportunity to at least inspect this briefly,
Yes, it looks like my husband's signature, yes.
and this is the only signed document regarding the premises.
Yes,
Okay. And Mr. Mills, your allegation previously had been that the allegation that's contained in your answer is that the plaintiff was seeking to enrich herself and benefit from the improvements you had made to the property.
Essentially, yes, Your Honor.
Did you bring any proof of that defense with you, sir?
My proof of defense that I brought was the contract that I entered in with Mr. Schramm. The proof in my answer to this complaint has all been verbal between Mrs. Schramm and myself, and she's stated that she wanted to get someone in there that would pay significantly more to rent the property. And the allegation is that in fact, the reason the property would possibly be of more value is because of the that I made. However, with the contract being entered today, I'd like to ask for a motion to dismiss this case with prejudice, based on a viable legal and binding contract that I continue to make the performance of. And her her complaint says that I violated a verbal contract and defaulted on a verbal contract. I don't know of any verbal contract I defaulted on. And I have a written contract that I have not defaulted on, and at this time, I would ask for this to be dismissed.
Mrs. Schramm, were you about to say something?
I was, Your Honor. It's a very small rent that he has been paying, and of this year, this is the 10th month, I've only received 2 payments this year. He also owes me $2,436.
He also owes, I'm sorry,
$2,436
from past what, ma'am?
rent.
Just rent?
Yes,
And those numbers are disputed by me.
plus court costs.
Well, here's the issue, Mrs. Schramm. You filed the case as a termination of tenancy, not as a non-payment case. Is your effort today to collect the rent or to have the property returned to you?
Whichever can be accomplished
No, ma'am.
to evict them.
Okay. Mr. Mills, the issue before the court is a termination of tenancy. There was a notice to quit delivered to you on June 6, 2022. There was a copy of it attached to the summons and complaint in this matter that was served on you previously. And one of the reasons that the court asked for the matter to be adjourned was that you made the allegation that you had some greater right to the property. The lease agreement that you've presented to the court this morning does not provide you any greater protection than any other tenant. She's giving you a 30-day notice to vacate the property. What is your defense to the 30-day notice?
My defense is that contract, I'm not sure if you read all what the contract reads, but it specifically states that I am able to retain the property and make the payment of the taxes or the $1,200, whatever is greater. And I am allowed to keep this property until it goes for sale, and then I have the right to buy it. Mr. Schramm and myself have never had an issue. We've always had perfect communication, and quite frankly, he would not be pleased with what's going on with this today in this courtroom. I've fulfilled my obligation, and her numbers and my numbers financially are substantially different. And the way I interpret, not what I interpret, what I have paid, I'm about 11 months to the good as far as what I've paid on this contract. And I don't, there's nothing that I have defaulted on in that contract.
Mr. Mills, I did read the contract. It's signed it says entered into on February 1st, 2012 for you to pay $1,200 per year or the amount of the property taxes, whichever is greater. And it sets your payment schedule at monthly payments of $100 per month.
What it actually says is when it's due, requested due, Your Honor, if I may go backward just a little bit. The $1,200, when she says it's a very small amount of rent, she's absolutely right. But that amount was, when I met Mr. Schramm, I asked for permission to bow hunt at that property. Mr. Schramm said to me, if you want to pay the taxes on that property, you can do whatever you want. At the time, the taxes were, I believe, just shy of $800. I continued to hunt on this property for, I believe it was about 2 years. I had at the time another building in Huron Township on 1 acre, fenced in, with a beautiful garage that had 0 problems, that I paid $125 a month. I went to Mr. Schramm. At the time, he had a dilapidated building. It didn't have a roof, it didn't have doors, it didn't have an east wall. It had several abandoned junk cars. It had piles of garbage higher than your honor's manual here. And I asked him what his thoughts were on me improving the property, getting rid of the other property that I was leasing to store my belongings in, and fixing the barn up. And he said that'd be fine, and we'll continue it at the payment of what the taxes are. We made the $1,200 for a roundabout figure, so it wasn't down to 42 cents or whatever. And he said, it's not worth me driving over here for $100. I'll see you every few months, and the history of my payments that we have on file show that I've never made monthly payments in the 11 years. It was never asked of me, and it never has been. He would come to me and I'd give him 500 or 600. Sometimes I was 6 or 8 months to the good. Sometimes I was 4 months to the bad. We had that agreement and we have that on paper, and I can prove and establish that those monthly payments were never met and never requested and never asked. So again, what I'm paying is I'm not paying rent, I'm paying the taxes on this property. And I cleaned all the debris, I removed the carts, I built the roof, I built the wall, I installed the doors, I put the fence up. I cut all the trees down. The building was taken over by Mother Nature. There was nothing there but a vacant pile of garbage. Now it has a nice barn, it has a nice lawn, the trees are cut, the yard is trimmed, the driveway's in, a nice cedar fence is there. It's been insulated, the roof, the thieves had stolen all the wiring. The wiring is back intact, and those things over the course of years have cost me thousands and thousands of dollars. Now she says that barn should be rented for $400 a month, and she's absolutely right, but she didn't have a barn, she didn't have a yard, and she didn't have a fence, and she didn't have a roof, and she didn't have doors. What she had was junk cars and a pile of debris. And now that I've made it nice, I do not feel, number one, that it's clear in the contract that it shouldn't happen, but I don't feel that she should kick me out in an effort to rent out what I've created for her financial gain. It's simply not fair, and I don't quite frankly think it should even be legal. It's unjust enrichment is what it is. And I would have never, A, I never would have left my old building. B, I never would have put all my time and money into that building had I not made it clear with a contract that I was never to be leaving there. And Mr. Schramm and myself had a 12 or 13 year ongoing relationship. We never had an issue. We never were before this court. He never gave me an eviction. And as far as Mrs. Schramm, I've been making efforts for months to try to resolve this with her. She won't return my phone calls. She won't speak to me. I went and spoke with her son back in June. He told me that he spoke to his mother and it was worked out. I stopped back over there in July for him to work on my vehicle, and she informed me that they in fact did not work anything out. I thought this matter was resolved. I've tried to speak with her. She won't. I asked her if she wanted to raise the rent. I said I wouldn't even be opposed to talking about that. And let me back up again. I'm sorry, I'm getting ahead of myself a little bit. 1 year ago in September, we agreed on a purchase price to this property. And Mrs. Schramm and myself were in very good spirits and good nature. And she had her attorney draw a land contract. And her and I sat down in her attorney's office. And we were gonna sign that land contract. And I asked her if she could adjust the percentage, the interest rate. And she said she would. And then we were supposed to go back in 2 weeks and sign that paperwork. In that 2 weeks' time, her attorney and a real estate agent and some other people got in her ear and told her that she should never be selling me that property for the amount her and I agreed on. And she is under the impression, because Amazon built a warehouse across the street, that someday this property is going to be worth millions of dollars. And quite honestly, that's what the ultimate thing here is. She's already had a real estate agent go look at it. She, in my belief, had the township, give me an ordinance violation to get it all cleaned up. And once I did get it cleaned up, that was when this was brought before this matter. So, I think it's just a backdoor effort for her to get me out of there, because again, I've tried to have negotiations with her about money, and I've tried to get this to where we were in agreement. She doesn't want that. She wants me out, and she wants to try to sell it, or she wants to try to rent the barn that I built that she didn't have. And that's exactly what's going on here today. If this was about money, her and I would have resolved this months ago. She's refused my payments. She's refused my phone calls. She's refused my text messages. I've made several efforts. I'm not paying her. In the last 7 years, I have paid her over $13,000. And my math, 7 times 12 is 8,400. That's over $5,000 more in 7 years than my contract states. You know, she's put, I've received some notifications from her where she changed the rent to $125. And then there's some months where she's decided to put late fees. Those things aren't in the contract. The contract states a price. She decides that she wants to raise it just because of inflation. There's a provision in that contract for this to go up if her taxes exceed $1,200. I'm not asking for anything for free, but what the agreement we had was Mr. Schramm was extremely happy. I paid the taxes and he was able to retain the property. And if it was end up worth $1 million, then he would be the one to get the $1 million. And I paid the taxes for almost 14 years. When I started there was a horse track across the street. And
Okay,
so, yeah, I think I made my defense as to what.
I wasn't sure how far down the road it was. So now, thank you.
There was a horse track just being built. It wasn't even there. So that's how far back. And there's Google Earth pictures that you can go to 2012 and see what this property looked like. And you can see the progression through the years, what has been done. So, I mean, I guess in closing, I'd be more than happy to financially come to an agreement with her, but my contract specifically states that the only way for me to leave is if somebody offers to buy that and I decline to match that offer, and then I leave. I've paid the taxes. I've completed my performance of this contract.
Mr. Mills, I don't think that that's quite an accurate understanding of the document. It gives you first right of refusal if the property is to be sold, but it doesn't give you a lifetime rental of the property, if that makes sense to you.
It does. It doesn't necessarily say lifetime, and the only thing that, in hindsight, I should have made that, I wrote that contract, obviously, and again, he and I were on good terms. It was, I never in a million years would have been in front of a judge between Mr. Schramm and myself. This would never even be happening. So I was a little lackadaisical. I didn't consult an attorney. I am not an attorney. I am a college educated man that has a well-rounded knowledge of business and contracts, being a business owner. However, there is no end date, but it does say as long as I continue to pay these taxes. And right now, according to my math, I'm about 3 years ahead in the taxes. So for me to be evicted when I'm 3 years ahead in my rent, I don't see how that's possible. I didn't get petty and metal when she said she wanted $25 more a month. I just gave her $25 extra a month. There was no verbal agreement that I changed the written contract. And quite frankly, you know, in her motion, it says I defaulted on the verbal contract. I to this day haven't heard what this verbal contract is. If Mrs. Schramm wants $100 a month on the first of the month, I have no problem mailing her a check for $100. But her husband and I, for the last 14 years, decided that it was a waste of fuel for us to meet up every 30 days for a $100 bill. And that's what this is about. It's not about me not paying my bill. And again, I've been trying to, I haven't pressed the issue on the offense, but again, I've added up this math and I paid $13,000 in 7 years on an $8,000 obligation, $8,400 obligation. So if push come to shove, again, I'm about 3 years to the good. I would be more than happy to get a meeting of minds and ask Your Honor to try to make this, this work. I thought our first meeting, I thought was supposed to be mediation. I've never spoke to a mediator. No one's asked me, you know, when I first called about this, they said, well, your first one is gonna be a mediation, and then you're gonna have this hearing and that hearing, and quite frankly, none of that has occurred. It's been adjourned, and then I would have brought that document. Again, I had to go look through several boxes in my basement, but I thought I had a jury to explain my case to, not Your Honor. So I didn't even go looking for that because quite honestly, I was hoping and assuming we could resolve this before it got to a jury. But I can assure you that I could convince a jury of my peers that I am not in the wrong here, and what she's doing or attempting to do is not right morally or frankly legally. I've fulfilled my obligation. So you said there's no end date to that contract. You're right, there is no end date, but my performance continues to be met. So how would that contract terminate? The way I interpreted it and the way I worded it and the way the two people that entered into it was believed and agreed upon that I would be there as long as I wanted to be there. And the only way I would be leaving there, quite frankly, I've never planned on ever leaving. I was waiting for him to want to sell it, and then I was going to buy it. And again, I was supposed to buy it a year ago. We met with her attorney, and he told her, and she called the deal off. After she'd been agreeing all of last year, she agreed, yeah, that's a wonderful idea. I'm ready to sell it. This is what my husband said I wanted for it. This is what I'm going to agree to take. It was, the wheels were in motion. We went to her attorney, and he got in her ear and told her that price, you're foolish for selling it. And then she backed out. That's what happened, period. And that's what, again, the property is worth what it's worth because I have about $40,000 of my own money, time, and equity into it. And I never would have done that had I thought I could be thrown out for no reason.
Anything else, Mr. Mills?
I don't think so right now, Your Honor.
Ms. Schramm?
All right. My husband was very angry with Mr. Mills for not paying promptly over years. Anyone in hearing this has heard about it. Why, if it was so beat up, did I get 7 complaints from Huron Township Ordinance Officer?
This is irrelevant.
No,
Last year, he paid 5 payments out of 12. This year, he paid 2 payments out of 10. My lawyer advised me, John Day, my lawyer advised me not to get involved with Mr. Mills. He said, if you sign a land contract, it's not going to work out well with this sort of person. I'm a widow. I have trouble making it on $400 a week. My husband advised me not to sell it until the price was up for the property, and I need more income. Mr. Mills has demonstrated over many years that he does not keep up his payments. I have a sheet here if you'd like to look at it of how his balance mounted up over the years. And I have it more detailed by the month. I don't believe the property was ever in such a shape as he said. I know he has put time and effort into it. The building was never that dilapidated. There was never that much junk there. Very little. And I think that's about what I have to say.
Thank you. Mr. Mills, in answer to your question or your inquiry about being able to present your case to a jury of your peers, this court cannot schedule this case for trial if there is not a triable issue. When we first started, the first thing the court asked, well, one of the first things that the court asked of Mrs. Schramm was she seeking recovery of the property or was she seeking the payment of rent? And she said recovery of the property. So the court is stuck with the complaint in this matter. At the time that the case was filed, no copy of the lease agreement was provided to the court. What Ms. Schramm attached was rental payments going from 2016 to 2022, which is why the court thought that this would be about money. But it's not. It is about recovery of the property. And what Mrs. Schramm originally produced to the court and what the court reviewed this morning is that the tenancy shall be terminable upon 30 days written notice served by either party. And so the court thought that that's all that it was, that 30-day notice that Ms. Schramm forwarded to you on June 6th would be sufficient to terminate your tenancy, where it indicated that you must move by July the 6th, 2022. And when we were last here, I inquired and you said that you had 13 years of boxes in the basement or something that you had to go through to find what you needed to present your defense. And you did. You have the only signed copy of the lease agreement from February 16, 2022, and the court went immediately to the payment schedule that says monthly payments of and . So we're thinking it's a monthly agreement. But the lease agreement at paragraph 1 sets the term of the lease as 1 year. It says, I agree to pay $1,200 per year every year, which the court's reading of takes this as a year-to-year lease, which means you have to be given equal notice. The period that your lease is going to be terminated has to be equal to the term of the lease. That being the case, she would have to give you, in this court's estimation, a 1-year notice that she was not going to renew your lease if she was seeking to terminate your tenancy, which is what she's doing in this case. By Mrs. Schramm only giving a 30-day notice, the court's belief is that the notice is deficient and defective, and the court will grant your oral motion to dismiss the case only on the issue of the termination. The court cannot force Mrs. Schramm to continue on with you as a tenant. If she brings the case again as a non-payment of rent case, it changes the posture of the case. Do you understand what I'm saying to you?
I do.
Okay. Court can't force her to sell the property to you. The court can't force her to continue on in the $1,200 per month or the property taxes. The lease as it is written might have been sufficient between you and Mr. Schramm with your handshakes and your additional conversation about it. But when you have a written document, that's what's binding upon the parties. If you are able to, the two of you are able to have a conversation either directly with each other or through attorneys on how to get a better, more current and accurate lease in place, that's another conversation for another day. But this court's finding that the notice is defective will dismiss this case, and that will resolve this 223450 LT termination tenancy case that's before the court this morning. I will have the court clerks prepare the order of dismissal. Anything else, Mrs. Schramm?
I don't think that's a fair judgment. He has not kept up with his payments.
And Mrs. Schramm, I asked at the onset, is it about recovering the property or is it about the non-payment of rent? And you said recovery of the property. And I explained to you at the beginning that those are two different things. This does not preclude you from filing a new case as a non-payment case. Okay. Anything else, Mr. Mills?
No, thank you, Your Honor.
Thank you.
Is that paperwork gonna be mailed, Your Honor, or are we waiting for that paperwork?
It will be mailed because the file needs to go downstairs to the clerks. Thank you.
Have a good day.
You too. Mr. Patterson,
Yes, Your Honor.
what are you here for this morning, sir?
Judge, that's on my case.
Oh, thank you, Mr. Robinson.
Good morning,
Oh,
Judge.
Ms. Schultz, Mr. Robinson, did you need to speak to Ms. Schultz?
I don't believe so, Judge.
Okay. This court also has arraignments this morning. I'm looking for. I don't see Mr. Jadala as of yet, so let's call this landlord tenant case. This is 224111 LT. This is the estate of Ronald W. Patterson versus Mary Schultz. May I have your appearance, please?
Good morning. Excuse- Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of the estate of Ronald Patterson Jr. With me is Ronald, or actually not with me, but also on Zoom is Ronald Patterson, the third duly appointed personal representative of the estate of Ronald Patterson Jr.
And ma'am, would you state your name for the record, please?
Mary Schott.
Shots, thank you. Today is the day and time scheduled for hearing on this termination of tenancy matter. The court did inquire whether or not the parties needed to speak. Mr. Robinson said no. That being the case, Mr. Robinson, how do you wish to proceed this morning?
We're ready to proceed with the hearing, Judge. With the understanding, I have not received any type of responsive pleading from the defendant. I'm not 100% sure what her defense is, but we can proceed with our proofs.
Thank you. Ms. Schatz, what is your response to the complaint in this matter?
My defense, Your Honor, is I have been there from day one. I have paid the majority of the bills since 2011 with his father before he just passed away. I cannot find housing. I am actively looking. I have searched probably at least 500 places. Rosa from the senior citizens place there in Romulus has also been helping me, and she is also turning up zero. This house goes up for auction in 2 days on the Wayne County site. It's on there. I've spoken to the attorneys. They've posted it on the garage. I presented that the last time, Your Honor, that we went through this. So I'm not sure what this is really about.
Ma'am,
I need
you
more
have the
time.
You have the court at a disadvantage because you said you've been there since day one. This is the first time this case has been scheduled in courtroom number 1. And
Yes,
all that
ma'am.
I have is the summons, the complaint, the notice to quit, which gave you 30 days notice to vacate the property. There was no lease attached. There was nothing written in response from you.
Your
So I'm
Honor,
not sure.
I have been actively trying to get an attorney. I financially can't afford it. I have made multiple phone calls. I cannot get a phone call back from anybody in that department to represent me. So I'm trying to do this on my own. And quite frankly, I'm a little lost.
In Your Honor, if I may just interject briefly, I think the defendant is referring to the pretrial.
No, I'm not.
I-
No, sir. Let me clarify, please.
No, ma'am,
I'm
no,
ref-
no, that's not how it works, because you interrupt doesn't mean you get an opportunity to speak. Mr.
Okay.
Robinson was responding, and I'll ask you a follow-up question here shortly.
Yeah,
Robinson.
and Judge, as Your Honor correctly pointed out, this is the first time we were before you. But I had previously indicated to the defendant that if she has any monetary claims relating to expenses relating to the house, that certainly she's able to file any type of claims in the probate court. But Judge, we can't move on the administration of this estate as it is right now. There is no lease between the parties, and it's unfortunate. They were in a partnership, a relationship, I should say, Judge, not business partnership, but relationship. But I haven't heard a valid defense to this, and the notice to quit went out back in July. So, but again, Judge, I'm willing to take some testimony here.
And Ms. Shaws, that was going to be the court's question to you, because based on your comments and Mr. Robinson's now response, is it the understanding that you occupied that premises with the decedent in this case?
That's correct, Your Honor.
And so there's no lease?
No, ma'am, there is no lease. I'm sorry.
Go ahead.
No, ma'am, when I was working, my paychecks went into his bank account to pay bills, to make house payments, all of it. When I became disabled in 2016, I was still paying the majority of the bills. I took out a personal loan in January for $4,000, and I can give you the information. You can call the person and check, to pull him out of debt. This is a loan that I now have to pay back, along with a lot of other things. I cannot find a place because I am disability Social Security. I'm not old enough to get into a senior place. There is a 3 to 5 year waiting list on the majority of places. I'm batting zero. I don't want to be homeless. This house, like I said, goes up for auction in 2 days. Should I not be dealing with that as opposed to Mr. Patterson Jr.? I'm not quite understanding this. And respectfully, sir, the attorney, I was not aware and never heard you say or tell me that I had a right to file an appeal or to respond. So I'm not understanding that statement at all from you.
There are two different things, ma'am. I think what Mr. Robinson was referring to, I'm sorry, I was getting an update on the arraignments. What Mr. Robinson was referring to is that you have a right to file a claim in the probate court for this loan and these payments and these monies that you think might be owed to you from the estate, which is a separate case. That's probate court downtown.
Yes,
For
ma'am.
the case here today, this is a landlord-tenant termination of tenancy case, and nothing in these documents made it clear to the court that you were a partner, life partner, romantic partner, I don't know how, whatever words you want to use, with the named owner of the property. So there's no lease. So you are you're an occupant of the property. So the question becomes, do you have a defense to the notice to quit? Mr. Robinson has indicated on the record, and the review of the file shows that you were served with a 30-day notice by first class mail back on July 5th, 2022.
That's correct. I did receive that.
So once you receive it, you have noticed that the plaintiff is asking you to vacate the property, and it says here by August 6th. Your defense would be that you're somehow entitled to greater than a 30-day notice, that the notice is defective, that you're an owner of the property, or that you have some greater right to the property than
No, ma'am.
an occupant.
No, Your Honor, I do not feel that way. I have invested many years of my life into that property. I do not own the property. My name is not on the property, and neither is Mr. Ronald Patterson Jr. at this point that I'm aware of. What I'm asking is that I be given some time to find a place. I am actively looking every single day and I am coming up zero. And I have other people as well trying to help me find a place. Rosa at the Romulus Senior Citizen. Between her and I, we've called at least 500 places, and there is no availability.
Mr. Robinson, you were starting to say something.
No, I was just going to concur with the court that I did not advise her as for an appeal. Just as the court indicated that if she's got any monetary claims for reimbursement, that those should be made against the estate. So.
And Ms. Schatz, what Mr. Robinson indicated pretty early in the proceedings was that he was willing to, well, was available for testimony to be taken this morning. But in order for there to be trial, there has to be a triable issue. And you've acknowledged now to the court that you received the notice to quit, you clearly received the summons and complaint as evidenced by your logging on this morning.
Ma'am, I'm sorry, Your Honor, I can barely hear you.
Oh, I'm sorry. I said for there to be a trial in this case, which is what the case is scheduled for hearing this morning, there has to be a triable issue. You've acknowledged receipt of the notice to quit. You've acknowledged receipt of the summons and complaint by virtue of you appearing this morning. And the court is listening for a defense, and respectfully, an inability to find alternate housing or your next housing is not a defense. It might be a reason why the plaintiff allows more than 10 days, which is the statutory requirement, but it's not a defense to a termination of tenancy case.
Okay.
Okay. Mr. Robinson, was there something you were going to say?
No, Your Honor. The only other thing that I would add is that the spelling, I guess, from Ms. Schott is incorrect on the pleading. I wanted to make that clear to the court in that pursuant to MCR 2.118 C2, I just asked the court to allow me just to amend to correct the spelling on that. Ms. Schott has indicated that she has received all the documentation. I don't think there's any issue.
And Ms. Schatz, the correct spelling of your last name?
SCHOTT.
Thank you, ma'am. There being no triable issues in this case, the court would enter judgment in favor of plaintiff and against defendant to return the premises to the estate of Ronald Patterson. Mr. Robinson, are you able to or authorized to allow more than 10 days for Ms. Schott to vacate the property?
I am not, Judge. And Mr. Patterson, who is actually my client vis-a-vis the estate, is on with us right now. And Judge, I think the court knows me pretty well. I'm pretty reasonable in these situations, but this again it's been going on even prior to the July notice, but officially at least since July. That goes well beyond what even I would normally advise my client in terms of extension. So, but I do not have the authority, Judge.
Your Honor,
Ms.
may I
Schott.
say something, please?
Yes, ma'am.
I would like at least another 30 to 60 days. The house is going in auction in 2 days on the 20th. I've already spoken with the attorneys through Quicken Loans. They've been on the front porch. I've had conversations with them. They've posted it on the garage door on the 20th.
Judge, just if I may clear, I'm sorry, Ms. Schott. Oh, Judge, if I may clarify that, not as if that's an issue or not, the estate has already remedied that situation. It's a non-issue at this point. We've taken care of any of that, so.
This court won't get into the probate matter Ms. Schott has indicated on the record multiple times that she has been in that property for, she hasn't said exactly how long. She says day one. If this was her partner and their intention and the way they lived was to live a certain way, and now that he's deceased and she's being asked to vacate the property, I don't know how the parties get to a place where 10 days seems sufficient. I understand that the notice was served back in July, but
Exactly. Your Honor,
if Mr.
Ronald
Patterson's
Ronald Patterson and I were intending to be married in May. We were flying to Vegas to make that happen because he and I had been together 14 years. He and I had been together on 2 previous properties other than the Romulus one.
Ms. Schott, the court can't make a contract where it does not exist.
I
And if
know.
If Mr. Robinson's indication on the record is that his client, the representative of the state won't allow more than 10 days, the court has to enter judgment that says that you have 10 days to vacate the property. Mr. Patterson is here. If he wishes to go beyond the 10 days, all he has to do is nod his head and we'll figure out from him how much longer time he'll allow you to remain in the property. The court can't make him.
I
The court would just
understand.
ask for some grace and some understanding from him, but I can't make him.
I understand. Yeah, 30 days would be lovely. And thank you, Your Honor.
Mr. Patterson, as personal representative for the estate, will you allow more than 10 days for Ms. Schott to vacate the property?
Honor, I'd like to respectfully decline.
Of course.
Understood, sir. Again, Ms. Schott, I can't make him. Mr. Robinson will submit a judgment to the court that will find there is no tribal issue, that you have 10
Ma'am.
days to vacate the property.
Do I have the right to appeal that? To file an appeal on that judgment?
Ma'am, you have an absolute right to appeal any decision of this court.
Okay,
And to judge, in the SCA judgment form, as the court is well aware, provisions relating to appeal rights will be included in that judgment.
The very bottom of the form, ma'am, will tell you what you need to do if those are steps you wish to take.
yes, it is. I will
Anything else,
appeal
Mr.
that.
Robinson?
I'm sorry, Judge.
I said, anything else, Mr. Robinson?
No, Your Honor, thank you.
Anything else, Ms. Schott?
Yes, ma'am. Do I need to come down to the courthouse to file the appeal? I mean, can I do that way?
You can do, they can provide the forms downstairs for you.
Okay. Okay, very good. Yes, I would like that. And monetary, how much does that cost to file an appeal?
I honestly don't know anymore, Ms. Schott. It's been
That's
probably
okay.
10 years since I've had to do one, but the clerks will have that information, or you can find it online at Michigan Legal Help.
Okay,
Okay.
yeah, I'm betting 0 with all the legal help. I really do need an attorney, obviously, but I can't get one to call me back. It doesn't matter who I leave messages with. I'll figure it out unless you can.
Michigan Legal
Maybe.
Help is an online
Yeah,
thing that will answer some of your questions.
yeah,
Okay.
I've actually done that and left multiple messages. I can't get anybody to call back. So. Okay. So
Thank you,
yes,
ma'am.
I will be filing an appeal. Thank you, Your Honor. I appreciate you.
Thank you.
Have a good day, ma'am.
Thank you, Judge.
Thank
Good morning, Mr. Jadala.
Good morning, Your Honor.
Did you go into the breakout rooms already?
I did. I spoke to Mr. Ferguson only. Was there another breakout room for the Van Buren defendants?
There must be, because I don't see them.
Okay,
Let's do Huron, and then they'll let you go back in for the other 2.
sounds good, Judge.
There is 220706 FY. This is State of Michigan versus Brian Ferguson. May I have your appearances, please?
Your Honor, respectfully, Samer Jadala, P62186, appearing on behalf of Mr. Ferguson, who appears via the Huron Township Jail, Your Honor. Your Honor, for purposes of arraignment, we'd waive formal reading and stand mute. Mr. Ferguson does understand what he's being charged with, as well as the possible penalties. I've gone over his rights. He does understand those. At this time, we'd respectfully request court-appointed counsel moving forward.
Mr. Ferguson, state your name for the record, please, sir.
Brian Lee Ferguson.
And Mr. Ferguson, you had the opportunity to speak to Mr. Jadala this morning.
Yes, ma'am.
You understand that you are here for your felony arraignment, sir.
Yes.
Mr. Jadala has indicated that you are waiving the formal reading and standing mute to the charges against you and asking for a court-appointed attorney. Sir, attached to the front of your file was the petition for court-appointed attorney. The court has signed that. You will be assigned counsel going forward. It will not be Mr. Jadala. The attorney assigned to you will use the phone number that appears on your petition to be in communication with you. Want to make sure that that's an accurate number. It was signed in 2 places. Sir, the next step in these proceedings is that you have an absolute right to be considered for trial release. There's a recommendation from law enforcement that your bond be set at 10,000 cash bond, and that you have no contact with the victims, the alleged victims in this case, those being Andrew DeLauder and Jamie Sue Ferguson. Mr. Jadala, what say you as to that bond recommendation?
Your Honor, Mr. Ferguson's 54 years old. He understands that there will be a do not return and also a no contact order. He does have an address. I'm sure it's the South Huron Road, New Boston address that he will be staying at if given bond. Your Honor, he's currently unemployed. He's not on probation or parole. He has no holds or warrants. He's been incarcerated for the last 4 days. We just respectfully request a reasonable bond in this matter.
Mr. Ferguson, the petition for court-appointed attorney that you submitted shows no employer and no source of income. Sir, how do you support yourself?
I pick up cans. I take junk, whatever I can. I garbage pick, whatever I can do.
Mr. Ferguson, the court has had the opportunity to look at your criminal history. It appears that your last case dates back to 2011. In reviewing the bond recommendation, there is no information to explain or support the request for a cash bond in this matter. The default position is for personal bond. I'm sorry, officer, were you starting to say something?
No, Your Honor.
Okay. Bond in this matter will be set at 10,000 personal. Condition of your bond, sir, is you do not return to the address where this offense is alleged to have occurred if it is. Do not return where this offense occurred, sir, and you are to have no contact with the complainants in this case, those being Andrew Emerson DeLauder, DELAWER, and Jamie Sue Ferguson. Sir, no contact means no contact, no direct contact, no contact with third persons, no contact through social media. If this court receives information or allegations that you have been in any effort to be in contact with these 2 complainants, the court could view that as a violation of the terms of your bond, revoke your bond, and you could spend the rest of these proceedings in custody. Understood? You understand what I'm saying, Mr. Ferguson?
Yes, ma'am.
The next date in these proceedings, sir, will be your probable cause conference, which will be on Wednesday, October the 26th, 2022 at 9:15 a.m. That will be in person with Chief Judge Brian Oakley in courtroom number 2. Again, the file number in this case is 220706FY. Next appearance date, October 26, 9:15 in person. Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Mr. Ferguson, October 26th with Judge Oakley, sir. Have a good day.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Bye.
I love your office this morning. Jessica Marie Gerhart.
Yes, ma'am.
Ms. Garrett, please.
This is 220473 FY. This is State of Michigan versus Jessica Marie Gerhart. May I have your appearances, please?
Your Honor, respectfully, Samuel Jadala, P62186, MIDC Arraignment Counsel, appearing on behalf of Ms. Gerhart. Your Honor, for purposes of arraignment today on the felony matter, we'd waive formal reading and stand mute. Ms. Gerhart understands what she's being charged with as well as the possible penalties. I've gone over her rights. She does understand those. She's going to respectfully request court-appointed counsel in that matter. And Your Honor, in respect to the misdemeanor matters, I've also gone over her rights on all those matters. She will be waiving formal reading and standing mute on those also, Judge.
Ma'am, state your name for the record.
Jessica Marie Gerhart.
Ms. Gerhart had been arraigned with an out county arraignment back on June the 25th, 2022. She was scheduled to appear for a probable cause conference on July 6, 2022, failed to appear. A warrant entered. That warrant has now been canceled by Van Buren Township. Ma'am, you have a right to, there's a new petition for court-appointed attorney attached to the front of the file. Ma'am, the court has signed that you will be assigned an attorney going forward. They will use the phone number listed on your petition to be in communication with you regarding this matter. Your felony attorney will not be Mr. Jadala. Ma'am, you have the right to be considered for pretrial release. The recommendation from Van Buren Township Public Safety is that they do not oppose personal bond in this matter. Mr. Jadala, do you have any comment as to bond?
Your Honor, we would not object to that recommendation of a personal bond.
Ms. Gerhart, the court in this case will set your bond at $5,000 personal. Ma'am, you do not need to post any money, but what you must do is continue to appear as directed by this court and participate in the proceedings until they are resolved in their entirety. The next step in these proceedings is your probable cause conference, which will be on Wednesday, October the 26th, 2022 at 9:30 a.m. in person with Chief Judge Brian Oakley in courtroom number 2. Again, the file number is 220473 FY. Next appearance date, October the 26th at 9:30 a.m. Ma'am, the officer will give you notice of that hearing date before you leave. You have additional matters, Ms. Gerhart. These are 20VB033840M, 210480OM, 210633OM, 200162OT. These are all Van Buren Township versus Jessica Gerhart. The 21VB033840M file that warrant has been canceled. And we'll have you stand mute to the charges against you. Set bond in this matter for $5,000 personal. Your next appearance date in this file will be pre-trial on November 3rd, 2022 at 9:40 a.m. And that will still be with Judge Oakley in courtroom number 2, 210480. Same thing, stand mute to the charges against you, 5,000 personal. Judge Oakley on November 3rd. 210633 OM. the retail fraud from July of 21. Have you stand mute, 5,000 personal. Appear with Judge Oakley on November 3rd at 9:40 a.m. The last case is 200162OT. You owe the court in that case $528. Please make arrangements to resume a payment plan in this matter. Be in contact with the court's collection department. Ma'am, you have a history of failing to appear. The court typically requires payment to set aside the bond and schedule the matter for hearing. You have been given the gift of having these warrants canceled. Please appear on November 3rd as directed by the court. Anything else, Mr. Jadala?
Nothing further, Your Honor.
Anything else from Ms. Gerhart Van Buren?
No, Your Honor.
Thank you. Mr. Jadala, you're welcome, ma'am. Have you had a chance to speak to Mr. Stoops?
I have, Your Honor. We're ready.
These are 220707 OM, Van Buren Township versus Jeremy Todd Stoops.
Respectfully, Your Honor, Sam Jadala, P62106, appearing on behalf of Mr. Stoops. Your Honor, for purposes of today's arraignment, we'd waive formal reading and stand mute. Mr. Stoops understands what he's being charged with as well as the possible penalty. We've gone over his rights. He does understand those, Your Honor. Your Honor, I've also let him know about 20VB 05815 from December of 2020. For purposes of that arraignment, we'd also waive formal reading and stand mute.
Thank you, Mr. Jadala. Sir, state your name for me, please.
Jeremy Stoops. Sorry.
Mr. Stoops, you had the opportunity to speak to Mr. Jadala this morning.
Yes.
Sir, he's indicated that he's waiving the formal reading of the charges against you, and you will stand mute to those charges. There is a recommendation from Van Buren Township Department of Public Safety indicating that they do not oppose personal bond in this matter. Any comment as to bond, Mr. Jadala?
Your Honor, we have no objection to the personal bond recommendation.
Mr. Stoops, your bond in 220707 from October, that just happened today, October 18th, interfering with police, will be set at 5,000 personal. You do not need to post any money, but what you must do is to continue to appear as directed by this court until the case is resolved in its entirety. Your next appearance date will be your pretrial on November 3rd, 2022 at 9:40 a.m. That's with Chief Judge Brian Oakley in courtroom number 2. In the 20VB 05815 OT matter, Mr. Jadala, the court notes your appearance, heard your indication. This is a driving while license suspended. Mr. Stoops, the court set your bond in this matter at 1,000 personal. Again, you don't need to post any money, but what you must do is to continue to appear as directed by the court until the matter's resolved in its entirety. This case will travel with with your next appearance date being that November 3rd, 2022, pretrial date with Judge Oakley in courtroom number 2 at 9:40 a.m.
Okay.
Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Anything else, Van Buren?
No, Your Honor, thank you.
Thank you. Have a good day. Good to see you,
Thank
Mr.
you.
Jadala.
Pleasure of mine, Judge Martin.
I can keep the other ones for just a second. I'll wait. I'm coming right now.